Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw. We bring to you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. First, let me update you about the ongoing Supreme Court's hearing on same-sex marriage. Today, the petitioners concluded their arguments and the Supreme Court started hearing the respondents opposing queer marriages in India. Primarily, the Union of India urged the Supreme Court to leave the question of granting members of the LGBTQ+ community an equal right to marry and regulation of such marriage to the wisdom of the legislature. Solicitor General Tushar Mehta appeared for the central government and said that a mere judicial declaration that LGBTQ couples have a right to marry is not enough. It will raise further questions as to how that right will be regulated. He said that the right to marry was not absolute even among heterosexual couples because they were bound by various regulations relating to marriageable age, ceremonies to be performed, bigamy, prohibited relationships, grounds and processes for dissolution of marriage, and so on. It would be impossible for the court to conceive all situations. Only Parliament could envision the situations that may arise and provide for their regulation. He also pointed out that if such marriages were to be permitted, as many as 160 legislations would be affected, leading to differences in the statutory framework of the country. When the law officer referred to some famous American cases on the need for judicial restraint, CJI Chandrachud asked him not to quote Dobbs versus X, the US Supreme Court's controversial decision that there is no constitutional right to abortion. The CJI observed, and I quote, "We have gone far beyond this case which held that women have no control over their own bodily decisions. This theory has been debunked long back in our country." I would like to remind the viewers here that the Supreme Court of India has already held that women have control over their bodily decisions. So when compared to the US, the Indian Supreme Court has far more progressive approach towards rights of women. When Justice Ravindra Bhatt pointed out that there were 9 such cases, such as Austria and South Africa, where legislation of marriage among LGBTQ couples was achieved through judicial intervention, the Solicitor General contended that these cases either would not apply to Indian context or were related to some particular prohibition that was struck down through judicial review. There was an interesting courtroom exchange that took place today. You can click on the link below to read the entire report. You can also watch the live proceedings of the Supreme Court hearing on our YouTube channel. Today, in an important update, the Supreme Court held that without completing investigation of a case, charge sheet or prosecution complaint cannot be filed by an investigating agency only to deprive an accused of his right to default bail under Section 167 of CRPC. Default bail is the right of the accused under Section 167, where if the charge sheet is not filed on time, the accused becomes entitled to bail by default. A bench comprising Justice Krishna Murari and Justice C.T. Ravikumar said so while considering a writ petition filed by Ritu Chabaria of Radius Group. Upon consideration of the petition, the bench made Ritu's interim bail order absolute. The bench also discussed the history of CRPC and the reason why amendments have been brought in Section 167 for default bail, and noted that if the investigating agency files a charge sheet without completing the investigation, that will not destroy the right of the accused to get default bail. In such cases, the trial court cannot continue to remand the arrested person beyond the maximum specified time without the arrested person opting for default bail. And now coming to an update on the petition moved by top women wrestlers of the country seeking registration of FIR against BJP MP and Wrestling Federation of India President Brij Bhushan Sharan Singh over alleged sexual harassment. Yesterday, as you know, CJI DY Chandrachud had issued a notice returnable on 28th April on the same. In response to the petition, Solicitor General Tushar Mehta, appearing for the Delhi Police, today informed the Supreme Court that the authorities first intended to conduct a preliminary inquiry in the matter. He added that if the top court directed, they were ready to register the FIR. Senior advocate Kapil Sibal, appearing for the petitioners, submitted that the petitioners will also be filing an additional affidavit. For more updates on the matter, stay tuned. In another important news, the central government has filed an affidavit in response to the petitioners challenging the Muslim Women Protection of Rights on Marriage Act 2019. As you know, in Shayara Bano versus Union of India, Supreme Court had declared the triple talaq or any other form of instantaneous divorce pronounced by a Muslim husband as unconstitutional. Post this, the Muslim Women Protection of Rights on Marriage Act 2019 was passed, criminalizing the practice. Challenging this legislation, a batch of writ petitions have been filed before the Supreme Court, and earlier this week, the Supreme Court decided to hear the petitions in November this year. The central government has now filed an affidavit in response to the petitions. The government states that despite the ruling of the Supreme Court, reports show that this practice of divorce continues to exist. And so, there was a need for immediate action to prevent the practice of triple talaq by making stringent provisions. The affidavit also states that despite the victims of triple talaq approaching the police for redressal of their grievance, the police was helpless as no punitive action could be taken against husbands indulging in the practice, even when it had been declared unconstitutional. Centre has also stated that the court cannot interfere with the legislation that has made punishable an act that the court itself declared to be violative of the Constitution. To read the full report, click on the link given in the description box. In another important update, a plea has been moved in the Supreme Court challenging the restoration of Lakshadweep MP Mohammad Fazal Khan's Lok Sabha membership, which was restored last month when the Kerala High Court suspended his conviction in an attempt to murder case. MP Fazal was convicted and sentenced to 10 years in prison by a sessions court in Kavaratti, capital of Lakshadweep, which comes under the territorial jurisdiction of Kerala High Court. Following this, he was disqualified from Lok Sabha. He challenged the conviction and it was suspended by the Kerala High Court. Last month, his membership was restored back by the Lok Sabha Secretariat. The present petition against the restoration has been moved by Lucknow-based advocate Ashok Pandey, who contends that once a member of parliament or state legislature loses his office by operation of law, he will continue to be disqualified till he is acquitted from the charges by some higher court. The petition goes further to question whether the conviction of an accused can be stayed by the Court of Appeal, and whether on the basis of such stay, can the disqualified person become qualified for membership of parliament or state legislature. He argues that Section 389 of CRPC only permits the Court of Appeal to suspend the sentence and not the conviction. The court can release the appellant on bail but cannot suspend the conviction. To stay updated on the same, you can visit LiveLaw.in. An important observation came today from the Delhi High Court. The court has observed that the use of celebrity names or images for art, satire, news or music is permissible as a part of the right of freedom of speech and expression under Article 19 of the Constitution, and it does not infringe the celebrity's right of publicity. Justice Amit Bansal stated that the right of publicity cannot be seen as an absolute right in India as there is no specific legislation for the same. In the present petition, Rario has filed a case against Mobile Premier League and Striker. Rario is a website run by a Singapore-based identity which is a subsidiary of Dream 11. The suit alleged that the defendants were minting and distributing NFTs which captured the images of players with whom the plaintiff Rario had entered into exclusive license agreements. And according to the plaintiff, these agreements exclusively entitle it to mint the tokens. So the defendants indulged in the act of infringement and breached the right of publicity. But the Delhi High Court dismissed the plaintiff's application and said that various online fantasy sports gaming platforms use names and images of celebrities and other information which are available in public domain. and that even if defendants were using players' names and images and statistics for commercial gain, it would be protected under Article 19 of the Constitution. As positive steps towards the transgender community, two important news are reported from Gujarat and Bombay High Court. The Gujarat High Court today issued notice on a public interest litigation seeking directions for construction of separate washrooms for the transgender or the third gender community. The matter was listed before the bench of Acting Chief Justice A.J. Desai and Justice Biren Vaishnav. In another case, the Bombay High Court has asked the Maharashtra government to issue directions to all educational institutions in the state to enable retrospective name and gender change for transgender persons in their records. A division bench of Justices Gautam Patel and Neela Gokhale observed that educational institutions should have a form on their websites for precisely such changes, that is, noting a change in name and a change in gender. Thank you for watching. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share, and subscribe and support us.